Welcome to Term Talk. I'm Hamid Khan, Judicial Education Attorney at the Federal Judicial Center. In each episode, we discuss Supreme Court decisions likely to impact the lower courts the most. Joining me are Erwin Chemerinsky, Dean, and Jesse H. Chopra, Distinguished Professor of Law at the University of California, Berkeley School of Law, and Michael McConnell, former judge of the United States Court of Appeals for the 10th Circuit, Richard and Frances Mallery, Professor of Law, and Director of the Constitutional Law Center at Stanford University. Thank you both for joining us. Today, we are talking about the Dormant Commerce Clause in the context of national pork producers versus Ross. Erwin, can you give us an overview of the Dormant Commerce Clause and how it applies to the facts of this case?
The Dormant Commerce Clause is the principle that a state local law is unconstitutional if it puts an excessive burden on interstate commerce. The key question under the Dormant Commerce Clause is whether the state or local law is discriminating against out-of-staters. If a state or local law is discriminating against out-of-staters and putting a burden on interstate commerce, there's a strong presumption against the law. The Supreme Court has said no state can use its laws to purposely discriminate against out-of-state economic interests. It's thought that one of the key inspirations for the Constitution was keeping states from adopting protectionist legislation. On the other hand, if a state or local law does not discriminate against out-of-staters, but it puts a burden on interstate commerce, it still can be challenged with the Dormant Commerce Clause. Then a balancing test is used. It comes from a case, Pike versus Bruce Church, where the Supreme Court said the law puts a burden on interstate commerce but isn't discriminatory. It's unconstitutional if the burdens on interstate commerce outweigh the benefits of the law. Well, National Pork Producer for Us involves an initiative passed by California voters, Proposition 12. It limits what pork can be sold in the state of California, and it says that the pork sold in California has to come from pigs that were humanely treated. It prescribes the specific conditions like pen sizes in order for the pork to be sold in the state. So the issue is, does the California law violate the Dormant Commerce Clause? The pork producers want to argue that the law is unconstitutional per se. They invoke what they call the extra-territoriality doctrine. It says that a state cannot impose regulations on business practices in other states. And they say that's exactly what's going on here. Most pork, over 90% of it, comes from producers outside of California, and so California is regulating them. The pork producers also argue that apart from the extraterritoriality principle, this is a law that puts a substantial burden on interstate commerce. California's response is that it's not discriminating at all. The law regulates what can be sold in California, and the same rules apply whether it's a California pork producer or an Iowa pork producer. The district court granted the motion to dismiss. The Ninth Circuit affirmed, and the Supreme Court, in a 5-4 decision, but without a majority opinion, also upheld the California law.
Michael, can you explain the friction points in the court's decision?
Yes, this is a very divided court, and it's not clear what the real holding is. So there was a plurality opinion of 3 justices written by Neil Gorsuch and joined significantly by Amy Coney Barrett. And the holding of this, the theory of this opinion is that the Supreme Court's Pike balancing test does not apply when the things to be balanced are incommensurable. So in this case, there's a balance of economic cost against the desire to improve the humane treatment of animals. Those things, there's no metric that applies to those two things. So these justices said, we simply cannot apply the Pike church balancing test in those circumstances. Then there were 4 dissenters who said, yes, we can apply, and the state law violates Pike. And then there were 2 other justices, namely Elena Kagan and Sonia Sotomayor, who said, yes, we can apply Pike, and the state wins under Pike. So that means that there seems to be a clear majority on the court that the Pike balancing test still survives. By the way, that's a huge surprise to me. I think the Pike balancing test is highly inconsistent with the court's more recent approach to constitutional jurisprudence. But in any event, Pike survives. And then to make things even more confusing, Justice Barrett, who joined the plurality opinion on the conceptual point about incommensurabilities, said that if she were to apply Pike balancing, that she would agree with the dissenters and not with Kagan and Sotomayor. Well, what does that mean? We've got a clear Supreme Court majority that Pike applies, and there is also a clear 5-justice majority that if Pike applies, the state loses. That is Barrett plus the 4 dissenters. This produces what scholars have long called a voting paradox, where the outcome of a case has a majority, in this case, the plurality plus Sotomayor and Kagan, but no one theory of the case actually commands a majority.
Michael, what other takeaways for the lower courts to consider?
Well, I think, first of all, the fact that Pike balancing is alive and well is a very important, significant, and to my mind, surprising development. It is not. It has never been overruled, but it has not been applied in recent cases, and I think largely looked like it was on the dustbin of history. But it's back, so undoubtedly we'll see lots more cases of this sort. But another thing is what the court really didn't do is it didn't grapple with the extraterritoriality argument that Erwin mentioned. The Pike balancing is really about so-called undue burdens on interstate commerce. But the real problem with the California law was not that. The real problem was that California is attempting, through using its own market power, attempting to require pork producers all over the country to comply with California law. Whereas in our usual system of federalism, each state gets to govern activities within the state and not elsewhere, unless there's some actual impacts on the people within California. But since the purpose of this law is to provide more humane treatment for pigs, the pigs are not in California. Essentially, what California is doing is using its market power to protect pigs in North Carolina. And that seems to be an extraterritoriality problem, which the Supreme Court basically ignored.
Erwin?
I disagree with Michael on this. I think Michael does an excellent job of presenting the argument from the pork producers, but all 9 justices reject the extraterritoriality argument. 4 justices dissent, saying under Pike balancing it allowed the case to go forward. I think that's one of the most important things about this case. Because if the Supreme Court had accepted the extraterritoriality principle, then it would be difficult for California to set fuel efficiency standards for cars, because most gas is produced outside of California. It would be very difficult for states to impose regulations. What the Supreme Court accepted is California is regulating what pork is sold in California, and that's something that a state can do. I think the case is also significant because it reaffirms the basic framework for Dormant Commerce Clause analysis. The starting point has to be for courts, does the state or local law discriminate against out-of-staters? If it discriminates, then there's a strong presumption against the law. Here the court said, and all 9 justices agreed, the California law was not discriminatory. If it's not discriminatory, then it's Pike balancing. And I'm not surprised that the court reaffirmed Pike balancing. In fact, 6 of the 9 justices here used and reaffirmed the Pike balancing test.
Thank you both for joining us today.